All right. How's everyone doing? We have a good week? Great, good deal. All right, well, I forgot to mention this last week, but we're holding steady here at 16% job approval rating for Congress. We were at last week we were at 18%, so it's gone down a little bit. So we're still in the teens there. So last time we were talking about the Commerce Clause, and today I want to try to get through the rest of the material on the Commerce Clause. Last time we've discussed the different eras in the history of Supreme Court decisions in which we've seen the kind of like morphing nature, the dynamic nature of how the courts have interpreted the Commerce Clause. We talked about what you could maybe call the Gibbons era, where the court had a very expansive view of Congress's commerce power, but Congress did not really do very much, if at all, pursuant to that power. And then we talked about the Lochner era from the 1880s to about 1937. 1937 is a hard kind of watershed beginning and end of the Lochner era, where you had the inverse, you had, or the converse rather, a Congress that was very active, very robust in economic regulation, commercial regulation, enacting legislation pursuant to the commerce power, but a Supreme Court that was very hostile to and had a very narrow and restrictive view of the Commerce Clause. And then in 1937, starting with the decision of the National Labor Relations Board versus Jones and Laughlin Steel, we see a dramatic shift of a court in the midst of the New Deal, a court that becomes very friendly and very supportive of Congress's economic regulatory agenda, and adopting a much more expansive view of the Commerce Clause. And we saw, I think, the height or the zenith of the court's construction, or the breadth of the court's construction of this clause in the Wickard versus Filburn decision. Anyone remember what happened in that case? What that case involved in Wickard versus Filburn? The farmer who grew wheat in excess of the quotas that were set by the Agricultural Adjustment Act.
Or his pigs.
I don't know if he had pigs or cows or what he had, but he violated the quotas, and he was subject to a fine for growing wheat in excess of the quotas. But remember, the issue was that none of his wheat left the farm. All of his wheat was not actually being sold on the market at all, not even to his neighbors, let alone the interstate market. And so the court adopted a cumulative effects standard, where Congress had the prerogative to look at certain activities and to regulate activities that were wholly local and wholly intrastate, that if taken in the aggregate, if you took the one instance and then multiplied it in the aggregate to look at what would happen and to regulate on that basis, that would bring the aggregated or cumulative effects of a wholly intrastate, wholly local activity could nonetheless come within the purview of Congress's power to regulate interstate commerce, because if that aggregate or cumulative effect substantially affected interstate commerce, then it was sufficient to bring it within Congress's power. That's very broad and very significant contrast to what had been the modus operandi of the court with respect to this clause of the Constitution just 10 or so years earlier. Wouldn't you say? Any questions so far?
Did you say that was a test case to try to get this attitude through?
Yeah, I mean, Mr. Filburn was a real farmer. But think today. Today you have legal advocacy organizations such as the American Civil Liberties Union, the Cato Institute, the Heritage Foundation, from all different persuasions on the political spectrum, that they will bankroll certain plaintiffs, or they will like to find certain plaintiffs to make a test case of, so that they can have a case to take all the way to the Supreme Court in hopes of either changing the law or advocating a certain ruling under the law, or to just win over public opinion, even if they fail to win the law. I mean, a good example of this is this not a Supreme Court case, but the Scopes monkey trial. Homer Scopes. That was the ACLU working in conjunction with Mr. Scopes in the state of Tennessee as a teacher in the public schools of Tennessee to teach naturalistic evolution, and he was kind of backed and planted there by the ACLU to bring about this kind of test case. They wanted this case to happen. So there's a sense in which we can look at Mr. Filbert and think he's just, the poor old dirt farmer with calloused hands trying to make an honest living, and he may have been exactly that. But that's not to detract from the fact that he was working with, if you want to call it a test case, that he was in cahoots with some advocacy interest groups that wanted to challenge the government. They wanted to challenge the AAA. Does it make sense? Yes, ma'am.
Wouldn't that be the same thing as Brown versus Board of Education, to force the Supreme Court to make a federal law on integration of schools?
I mean, you had a similar thing, and so there's a sense in which all plaintiffs that come to the Supreme Court, they're along the way interest groups and what we call amici curiae, friends of the court that submit briefs in support of certain positions that different parties take, that are trying to hoist a public policy or a constitutional or a legal issue before the courts, so that all can see, to kind of compel the court to make a ruling and to change the law, change society, things like that. So that's very well true as well. Yeah, that's a good point. Any other questions before we go on? Yes, sir.
You said this farmer, he didn't sell anything, but he was cited for raising more than what his quota was.
That's right.
I'm sorry, but I'm not figuring out how that can happen.
You're not the only one, don't worry. So Congress passed the Agricultural Adjustment Act, and it was in the midst of the Great Depression. And one of the factors that had brought on the Great Depression was the overproduction of row crops, and it had led to both basically the bottom falling out of the market because there was such a surplus of grain, and also it caused a dust bowl. So Congress has the idea of, well, if we maintain if we regulate the production of certain crops such that we can maintain it at the ideal level where there's not a surplus, and so farmers can get a high enough return on their crop yields to stay afloat and not to be, the Joad family leaving Oklahoma to head out to California. And that involves certain quotas. If you had 100 acres of arable land, if you had a 50-acre quota, you were not, unless you were ready to pay the fine, you could not cultivate that much wheat. So the issue with Mr. Filbert is that he didn't sell any of his wheat. All of his wheat was left onto his own farm, and so he says, look, maybe some of those other farmers that sell their wheat, maybe they're fair game for this law, but not me, Congress, not me, because I don't sell my wheat. My wheat stays here. Well, and so therefore, the AAA's quotas cannot constitutionally apply to me because I'm not engaging in commerce at all, let alone interstate commerce. And so the court said, no, we don't accept that argument, because if you were not growing your own wheat, you would be participating in the market. And so it's your activity that's being regulated because it is it's your non-participation in the market that multiplied in the aggregate or taken cumulatively would substantially affect commerce, and that's sufficient to bring it into Congress's power. It's a very controversial ruling, and it's a very expansive reading of Congress's power because how much more local do you get than not leaving your own property? Go ahead.
So you said last time, or sometime at the beginning, is there anything that's not commerce? And we tried to come up with ideas. And that would seem to be an indication. The guy plants his own stuff for his own use, but then the court said, even that is commerce.
Well, the court is not. The court's actually not saying that it's commerce per se. They're saying that it's an economic activity that affects commerce, and so as long as you have an economic activity that, if you take it in the aggregate, if you were to say, hey, if we Congress were to let everyone who wanted to do this do it, it would have an effect on interstate commerce. Then that notion is sufficient to bring it within the ambit of Congress's power.
That means everything is economic activity, right?
That's what we're going to get to. We're going to build up to the reaction where where people are starting to say, hey, there are limits here. And so hold that thought because we're getting there. Yes, sir.
Let's say we got to take into account the times and
Yeah.
what was going on in the country and what the Congress was trying to accomplish. Because I can imagine just a couple of years later, they didn't mind that you might have planted a whole lot because they had a war going on. They had a lot of people to feed, supporting a tremendous amount of activity.
Yeah.
And then when you got times that it goes up and times go down. I think, was it Nixon that said, or Butts that said, we're going to plant hedgerow to hedgerow.
Yeah.
And so that was the time then. And
Yeah.
now we've got, they've even taken out the hedgerows, and we've got people saying, gee, they've taken out the hedgerows. Now there's no place for birds. They're ruining the environment. Something else is going on. And so I think Congress is there to be responsive. And
yeah.
within the scope of the Constitution, which is pretty good.
Yeah, there's a sense in which I think Mr. Wellman has a point that the Constitution is made to be elastic, to expand to the exigencies of what the certain time periods, certain circumstances, social circumstances, economic circumstances that are in the present. The Constitution is expansive enough, or there's at least a school of thought that the Constitution should be expansive enough to accommodate those exigencies. There's another school of thought that would say exigencies be damned. The Constitution is what it is, and we should not, if we accustom ourselves to changing the fabric of of the limits of federal power and the scope of our rights and liberties according to the exigencies, then we've become wholly democratic, which some people may think is a good thing, and some people think is a bad thing. You lose the Marshallian notion of the rule of law at that point, arguably. There's two sides of this ideological coin. You see? Yes, sir.
Well, expanding on what he said, that victory gardens, that would
Yeah.
be a direct conflict of commerce. Telling you to grow your own instead of mine. Now, again,
Yeah.
during a wartime.
Yeah.
But they were promoting you to grow your own so
Mhm.
that you wouldn't dwindle supplies that were needed.
Sure.
Which
But
is-
but it's also, I'm sorry to interrupt, but think about, so maybe perhaps Congress had learned its lesson from what had happened at the end in 1819 with the end of the Napoleonic Wars, and in 1929 with what had happened after the end of World War I in Europe. No matter how war-torn Europe is, and how much of a infinite market it may seem to be in the midst of war or after a war, eventually the European market is going to get back to its feet, produce its own grain again. And if you have an American agricultural economy that's accustomed and built around this huge demand for in Europe for American food goods, that's going to eventually diminish. Then if you have an American agricultural economy that's built on that, it's not on stable ground. And so I think possibly Congress wanted to maintain just the ability to regulate the agricultural production because they understood that these things shift and they wane and wax. So I think I know you are mentioning with the advent of World War II. There's a huge demand for agricultural goods, but I think that doesn't diminish Congress's interest in having the power to regulate production. Does that make sense? Maybe not. I don't know. Okay, I really want to get through these cases today. Such interesting. I really appreciate you guys asked the most astute questions. I really appreciate it. Why don't we get through these questions? So, the New Deal, you do see this expansion of the court's interpretation of the Commerce Clause, and this expansive reading continues on in after the New Deal, after World War II, in the post-war era, especially in the Civil Rights era. And so the next couple cases we're going to discuss are both cases involving the Civil Rights Act. So the Civil Rights Act of 1964 was very, very sweeping legislation that dealt with primarily the issue of racism, especially to deal with the Jim Crow regime in the South. And what's interesting about this legislation is that it was the progenitors of the legislation only really intended it for it to apply to issues of race, and its opponents actually thought, if we tie on so many amendments to this, we'll make it so ridiculous that nobody can support it. And their thinking was, if we add women and religious minorities and national origin to these things, then all these people who are supporting it will see that it's ridiculous and they won't support it. That was the thinking of some of the more extreme fire-breathing, like the Strom Thurmond type in the South. Nonetheless, they added those amendments, supported those amendments, and the whole legislation passed. And so under the Civil Rights Act, thankfully, providentially you might say, we have not just race, but also sex, religion, color, and national origin that are also protected statutory classes. And what the Act does is it prohibits certain forms of discrimination on the basis of one's being in these protected classes. Discrimination on the basis of race, color, national origin, sex, and religion. For instance, Title VII of the Act applies to employment discrimination. So employers who are engaged in a business that affects interstate commerce are prohibited from engaging in discriminatory practices or treating employees adversely on the basis of their being or perceivedly being in one of those 5 protected classes. And now Title II, which interests us today, is not employment, but the avenue of public accommodations. So hotels, restaurants, things of that sort, public accommodations. That public accommodations cannot discriminate on the basis of race, color, national origin, sex, or religion. And so the first case we have here is Heart of Atlanta Motel versus United States. So it's Atlanta, Georgia in 1964. There's probably still a few people running around Georgia, maybe quite a few, who are of the segregation persuasion. And there's still lots of businesses, even after this act passes, that do not want to embrace racial integration for their customers or for their business. And so the Heart of Atlanta Motel is one of these. It's how many rooms did it have? I think I read somewhere, maybe I didn't put it in this excerpt here, but the hotel had 216 rooms. So it was a pretty big hotel for the time. And it was positioned, well, hold on. So what did the hotel do? What was the hotel doing that they were not supposed to be doing?
Refusing to rent to black patrons.
Yeah, they were denying accommodation to African American patrons. It was a whites only hotel. And so the hotel when it was subject to the penalties under the Civil Rights Act, said this is not constitutional. Because the Civil Rights Act was passed by Congress pursuant to its commerce powers. And the Heart of Atlanta Motel's argument is our decision of who our customers are, who we decide to serve, who we decide to contract with, that is entirely local. That happens right here in our hotel, does not leave the walls of our hotel. And so it is not interstate commerce. It is purely local. It's even more local than Mr. Filburn's growing wheat. And so Congress, this act, while it can apply to other things, it can't apply to us. It cannot constitutionally apply to us because if it does, it exceeds congressional power under the Commerce Clause. What does the court say?
That the patrons could come from out of state. It was not a local activity.
Well, do they focus on the fact that patrons could come from out of state? Or do they look at what's actually... They do. Most of the hotel's patrons are out of state. And it's right near, right off the interstate, right? And so they are engaging in, but for interstate commerce, this hotel is not in business. It relies on the interstate intercourse of persons coming from out of state to maintain its business. So it is the court's saying, nuh-uh, you are engaging in interstate commerce, very clearly. And so you are definitely within the ambit. What you're doing is definitely within the purview of Congress's power to regulate. And so yes, you must comply with the Civil Rights Act. Now, let me ask some questions here. Now, this is where we really, in the truest sense of the phrase, play devil's advocate. How can we think of a hypothetical situation in which a hotel could engage in the terrible practice of racial discrimination, but not be within the purview of the Civil Rights Act? Not to operate such that the Civil Rights Act could not constitutionally apply because it was not affecting interstate commerce. Can anybody think of how yes?
Could it be if you limited your customers to only citizens of your state?
Ah, okay.
How about
If it turned into
membership
a res-
private?
That's a good one. That's somebody thought of that though. Right after this case, there was a case called Daniel versus. There was a resort in Arkansas, and it was like a private membership, but they restricted membership in the club to only white people, and they tried that, and the court saw that. The court's argument, the court's basis of ruling against them was that all of the food items you're serving, all of the work that the contractors you're having do work here, it's all you are participating in interstate commerce. You cannot escape. They thought that's the first thing. That's one of the first things that some of these wealthy, kind of genteel, good old boy Southern clubs thought about, is to make things a private club. Didn't work for them because it was still a public accommodation, and they still got into commerce. So you said, what if they? Now that's an interesting idea. What if they only let rooms to in-state residents? First of all, they would probably go out of business, so they couldn't maintain that as a model. But hypothetically, could anybody? Let's say you did have. Let me back up. I want to come to that last. What if the hotel had a policy that required black patrons to show proof that they were in town for commercial purposes? What if they said, okay, we have to comply with the law, so we have to let you in our hotel if you're here on business. But if you're here just visiting your grandma, then no, because that's not commerce, and we're not gonna facilitate that. We're not required. The Congress cannot constitutionally make us rent you a room because you're not a commercial. You're not a commercial patron.
But they'd have to require it of white people too, otherwise it's discriminatory,
Well,
to prove the same thing.
not really. No, well, ultimately this doesn't work. But I'm suggesting a policy where white patrons, commercial or not, regardless of their purpose of being in town, are given accommodations. But in order for them to maintain some exercise of discrimination, they are saying, okay, the extent to which Congress can make us comply with this is to accommodate African American patrons who are in town on business, but not who are in town on non-business or non-commercial purposes. Could they do that?
But that's differential treatment still.
It still is. Yeah, it still violates the Act. But is that violation of the Act one that Congress has the power under the Commerce Clause to remedy by the Act?
Who knows?
Well, what about, do they have to buy gas? Do they have to buy food? Do they have to eat? They have to hire people?
That's really the reasoning of the Katzenbach case. You see, in Heart of Atlanta, it's and here's why. Okay, let me back up. The hypothetical that I just proposed does not work because go back to Gibbons versus Ogden. Commerce is not just buying and selling, remember? It's the intercourse from state to state. It's the movement of persons and goods regardless if it's commercial. Regardless if it's in a mercantile context. So that distinction, the hotel trying to say, okay, we Congress, you got us. We have to let African American patrons rent rooms if they're here on business because that's commerce, and Congress has the power to regulate that, to make us do that, but not people who are here to visit their family or here to go to a museum or something. Because the very movement of persons in interstate flow, regardless of their purpose of moving from state to state, is commerce. It's intercourse, like Chief Justice Marshall said. So that wouldn't work. Now, the difference between the Heart of Atlanta decision and the Katzenbach, the reasoning here was in Heart of Atlanta, the fact that the hotel was in fact right off the interstate, that most of their patronage was interstate guests, that brought them soundly within the purview of interstate commerce. They were participating in interstate commerce. With Katzenbach, you had a restaurant that was also engaging in racial discrimination, but they were 11 or 12 blocks away from the interstate, and they had a very local clientele, people they knew. And Charlie, good to see you this morning. Well, you'll have the usual, the same patrons coming in every day. So, what was the basis in Katzenbach for being, and this is something Mr. Wellman was hinting at, what's the basis in Katzenbach?
Interstate flow of food.
Yeah, the food they're serving, they're buying from local distributors, but the local distributors are getting it from out-of-state producers. So even though they're serving, do you see the difference here? In Heart of Atlanta, the clientele are in fact interstate. In Katzenbach, Ollie's Barbecue is serving ostensibly only a local clientele. Presumably everybody there is from Birmingham. But the food they're serving has crossed state lines and has been on the interstate market. Do you see these kind of two different bases, these two different hooks that brought these businesses in different ways into the scope of Congress's power to regulate? Do you see that? And so again, not trying to make light of racism at all, but for the sake of just for the sake of being devil's advocate, and realistic in the true sense of the word here, could you think of a way to have a restaurant or a hotel that would not, that to which the Civil Rights Act could not constitutionally apply. Now, you said if you required patrons to, like, let's say you required your patrons to show you an in-state driver's license. And beyond that, what if you had them, what if you opened up a restaurant and you, here in Warren County, and you required someone to show you their property tax documents showing that they own property here in Warren County. That gets pretty local. That excludes interstate clientele. So that's one component of it.
Local food.
Okay, local food. So what about the building what about your facility?
Where did the furniture come from? Who built the building?
Is there such thing as an establishment that's outside of Congress's power under the statute? I tried to think of one. I mean, think of, all right, I live out in Cleveland. Everybody know where Cleveland is? In Edmonson County? Everybody know where that is? All right, anybody ever been to Porky Pig's Diner?
Yeah.
Yeah. Now, I happen to know that Porky Pig's Diner actually has, by my suggestions, has had lots of interstate commercial patronage, because when I was a park ranger at Mammoth Cave, the people on my cave tours would ask me where they could go get something to eat, and I said, you better go to Porky Pig's Diner right past Cedar Sink. And I sent a lot of people from all around the world to Porky Pig's Diner. So they really owe me some commission. But, I mean, a place that's in the middle of nowhere, that, I mean, their patronage, you pretty much know everybody who walks in the door. But even they, under Katzenbach, are within the scope of Congress's power to regulate, because they are dealing with, they're selling and they are using items that have been, they're depending for the operation of their business, they're depending on interstate commerce. Anybody ever, I started to think of places when I was thinking, anybody remember, and I know this place isn't open anymore, it was in somewhere outside of Greensburg, Hook's Catfish Barn. Anybody ever go there? So it was an old, like, Tyson chicken barn, like one of those old long barns, and they like had a catfish, like a catfish pond, like one of those long catfish ponds there, and they converted this chicken barn into a catfish restaurant. And so they literally would catch the fish that they raise out of this aquaponics or whatever of this pond, and they'd fry the fish up there. And I remember you had to, when I was a kid, my parents would take me there, you had to like swing on a vine and ride a mule to get to this place. It was in the middle of nowhere. So I try to think of places that, or anybody remember Francis Barbecue in Tompkinsville? Anybody remember that? Anybody remember the commercials on the radio for Francis Barbecue? They were hilarious. They were like the fire and brimstone Baptist preacher, like preaching that Francis Barbecue was going to go to hell. And they were like, Francis Barbecue is an instrument of the devil. They were absolutely hilarious. And so I think that place like burnt down in 2015. But I wish they still would just air the commercials on the radio, because it was hilarious. But I mean, these tiny, yes.
Were these two cases brought to the court under the guise of the commerce, or did the justices pick the commerce to apply to these two cases?
No, Congress, when Congress wrote the statute, when Congress passed the Civil Rights Act, Congress declared in the first few sections of the act that racial discrimination, gender discrimination, religious discrimination affects interstate commerce. So there was a congressional finding and decree in the very text of the act, in the very text of the legislation, that says this is done with reference to the Commerce Clause, because this practice that we're wanting to get rid of really affects interstate commerce. Do you see what I'm saying? Yes, sir.
So the Civil Rights Act only protects those designated categories, right?
Yes.
So
The Federal Civil Rights Act, yes.
Could you have a restaurant or a motel that refused service to left-handed people?
Yes, of course. On the federal level, yes. You could have, I mean, to take this out of the context where it sounds like anybody is trying to make light of or justify racial discrimination. Let's say you had a restaurant that, let's say Congress, okay, let's say the 2020 ticket is Bud Kaczewski and Dick Vitale. And they take the White House and they get Congress to reform the Civil Rights Act to add Duke fans as a protected class. And they say nobody can be discriminated on the basis of being a Duke fan. I hate Duke. So I'm opening up a restaurant.
He's a grad, watch out.
Okay, I hate Duke, and I'm opening up a restaurant. I mean, when your mascot is literally the devil, well, you have problems. Okay. I don't really hate Duke, but let's say somebody really hates Duke, and they want to open up a restaurant, and they for darn sure do not want any Blue Devils or Duke fans coming into their restaurant. But how do they build a restaurant or operate their restaurant in which they are not within the purview where Congress can't regulate them? I mean, I think they would have to, like, you buy a farm, you cut down the trees, and you build like a log cabin, and you sell homegrown lettuce. But you have had to have somehow found the seeds for the lettuce on your farm. And I think there is going to be some hook, some way that you depended upon the interstate market of goods and services to create your restaurant.
The clothes you wear.
Exactly. Well, I mean, you would have to
have sheep.
Yeah.
And make the wool. And
Yeah. At some point, you have to be, Robert Redford, Jeremiah Johnson. You have to be like Jeremiah Johnson out in the wilderness. Just like, I'll hang my restaurant sign up here that I made out of bear hide. And so that you might be out of the purview of Congress's regulation, but can you operate a business that way?
But what if everybody did that?
Well,
In Filburn?
there you go.
Well, are you saying that Congress cleverly devised this statute to prevent any loophole? Or that's just the way it's been adjudicated?
No, I'm just saying that this statute has led to the courts interpreting the Commerce Clause in a way that some would say Congress now virtually has has plenary power. There's nothing is there anything that's outside of Congress's power to regulate now? Is Congress now vested with general police power like the states are supposed to be? The counter-argument to that would be, could this legislation work at all if Congress did not have that broad enforcement power to enforce it?
It ends up making the word meaningless. The word commerce.
And that's what we're going to get into. Let's move on. First of all, any other questions really quick? I saw a few hands kind of nudge up.
Well, you could discriminate for other reasons,
Yeah.
like
You-
no shoes, no shirt, no service.
Yeah, that's not a protected
Until somebody
class.
fights it.
Until lawsuit brought.
Well, yeah, but you can bring, this is the American way to bring a lawsuit over here. I can sue somebody for breathing my air. No, and then, I may have sanctions. If I'm a lawyer bringing that suit, I'm going to have Rule 11 sanctions. But as a plaintiff, I can bring a suit against somebody for just looking at me the wrong way. The question is that a viable cause of action that's recognized under the law? Either that's been carved out by the courts in the common law, or that's been created by statute by a legislature, either state or federal. So, to my knowledge, here, there's no state, federal, or local ordinance or law that requires someone to serve or to accommodate customers or clientele or patrons who are without shirt or shoes. Now, so on the federal level, it's only those 5 categories. Now, state and local level, they have the prerogative to add more categories: veteran status, sexual identity, sexual orientation, gender identity, political views, things like that. And so, but on the federal level, we only have those 5 classes. Any other questions? Okay. So now, like I said, in this era, it looks like the courts have really kind of dispensed with the Madisonian notion of dual federalism. Now it looks like, remember in the very first class we talked about different theories of federalism, where on one extreme you had the compact theory of federalism, where the ultimate sovereignty resided with the states, and that each state could be viewed as an independent sovereign republic that were just in league with the other states. And then on the other extreme, it looks as if the view would be the more Hamiltonian notion of a solitary, unitary republic, where the states are just kind of fade out, where they're not really important. It looks like here in this era, the New Deal and Civil Rights era, you have the cooperative federalist scheme. You have a federal government that looks as if it is possibly vested with plenary police powers. Now, when I use the word police powers, I'm not talking, the term police powers doesn't refer to just law enforcement. That's typically what the word police connotes. But police powers are defined as the prerogative to regulate the safety, health, welfare, and morals of a government's subjects. And so the states, under traditional federalism, have been understood to have general police powers, the power to regulate on behalf of the safety, health, welfare, and morals of their citizens. Congress, under the traditional federal understanding of the Constitution, has been a government of limited enumerated powers. Congress does not arguably have general police powers. But in this era, the courts began to read the Commerce Clause in such a way where some people began to suggest, okay, Congress now effectually has police power. Congress now effectually is a plenary sovereign. Do you see why they would think that? Because there's really kind of nothing outside of the scope of their regulation. Now, there are a lot of people still to this, even today, embrace this as, yes, that's very good. Because we could not have trusted states to reform the horrible practice of discrimination, and that's very true. But is this at the cost of the federal system that many would argue what the framers intended, or what the federal model for American government is? So then, an important thing kind of changed this. The election of Mr. Ronald Reagan. And Mr. Ronald Reagan, in the conservative revolution that happened in the 80s and 90s, came to power and began appointing more conservative justices and judges to the federal courts. And so you had judges now who had been influenced by a new generation of legal thinkers that began to be critical of the expansive bureaucratic, the expansive regulatory state, and the expansive constitutionalization of everything. So under the Warren Court, the Earl Warren Court, basically there was this huge expansion of civil rights litigation, because some would argue that the Warren Court opened the floodgates to all these kind of different civil rights cases that hadn't been there before. Some people would say that. But now you had more judges coming onto the federal bench who were critical of how the courts had been in this era, in the New Deal and Civil Rights era. And they began to try to recover the traditional notion of federalism, of dual federalism, of the notion of states having a proper sphere and the federal government having a proper sphere. and a more conservative, one might say right-leaning way of interpreting the Constitution, and an even more, I guess you could say, a conservative philosophy of jurisprudence and law generally. I don't have my watch today. What time are we at now? Yeah. You guys want to take a break before we go into the last few cases? Any questions? All right, we'll take a short break then.
Did you say his name was Loney?
Yes. Joe Loney. Cole, Loney, and Cox.
Cole, C-O-L-E?
Mm-hmm. I'll text him after class and advise that I'm send you his way, and then I'll shoot you his number. What's that? Yeah, I was just going to have people come and get them after class, but you can go ahead and hand them out. I'll just advise if anyone hasn't got one yet to get one. Thank you so much.
Something new? Yeah. Okay, well, we'll just take one. We should all start. You should know what.
Oh, I'm not going to gossip about anybody.
What about your
Okay.
Yeah, wherever you are, we
Oh,
can
yeah.
hear you.
We got him in the front row. What's it?
I'll let you see what the back says.
The back says extra ideas. Tell them to be careful.
I knew that was the case, but I appreciate you telling me.
Going to the restroom.
Thank you. Yeah. Engage in some of that bathroom discussion or something, or went out and called my wife or something. That would have been embarrassing.
It's all public.
Yeah.
On this theater, they want us to be that to that.
I didn't see the back. I didn't fill out the back.
Did you fill out one of these?
I did, just today.
Did you see the back?
I did.
Actually, Keith showed it to me. I didn't see it.
I
I
helped me with it.
have to tell Karen, put an arrow, turn the thing
Yeah.
over.
Yeah.
Flip it.
I didn't notice it at first, but I gave it a good show.
Okay.
So I picked a few more.
The good ones. They look better. I gotta keep the list going.
That's it. There were some good ones on there, I thought.
Now we just have to find the teachers.
I don't have that.
You're not gonna step up and teach them.
Well, all these issues you've been talking about are moral issues. You can't say there's a right or wrong. You can't say somebody that wants to start his own restaurant. You can't say who can eat there. If it's a public place,
Diaper changing.
that's where if they want to just invite you to their home, they can say, no, only white people can eat here.
You know, one thing I'm
Yeah,
trying to
that's,
figure out.
but at that point, that's a good question.
I was in
Congress had
school,
the,
I was in school in Atlanta, at Emory, when Maddox had that restaurant.
yeah, oh, yeah,
And I mean, you remember a little bit, read about that, I guess.
yeah.
Yeah, he fought that for a long time. He finally closed his restaurant.
Now, I'm familiar with Ollie McClung here that had this one, Maddox, and what kind of place did he have?
Well, he got a restaurant, he just only served whites.
Huh.
There you go.
You ever heard of Mr. Maddox even?
Oh, okay, I've heard that name before, I've not.
That big thing with that shifts back and forth. I thought it
That was in the sixties.
Uh-huh.
Well, now there may be one.
Yeah, there was
But no, there's one where you.
I mean, there was,
sit, like,
it wasn't like,
we're talking about babies.
people in the South were like, I mean, I guess we gotta follow the law now. That was not the case. And there's probably still a few places that are pretty hot. Yeah, and you go down pretty, Alabama, Mississippi, Georgia, I'm sure there's still a handful of pockets.
You see the movie The Green Book?
I haven't seen that. I heard it's really good.
It's a good movie.
I heard it's really good. I'd like to see it.
So that maybe a year or maybe a year. But the one on Covington is you can ride with your baby. So tell her that. I keep seeing all this stuff in the city of Lansing, but they're doing all this, and this, ones.
I've had fried fish.
Probably still is.
There's a splash pad, a binding frame, and everything's
Yeah, but they have good fried fish, yeah, because I've had it before there. Yeah.
Okay. She's always working. What's the answer?
Right.
And they're beginning to be.
They are,
I know
they
Liz
get-
on that study on skin.
Yeah, yeah. Well, she's the pipe queen, so she does a lot of stuff.
Down by the train station.
Yeah, and I've had it perfectly otherwise, on the doors to the rail park, but that's not open. To cater to parking for us, and pies and good stuff.
They were just barely walking.
Trampoline and
You are always right.
They have good sandwiches too.
okay, he's ready to start. Gotta make the whole house bouncy.
All right. So as we left off in the middle of the 20th century, it looked to most observers of constitutional law as if there was basically nothing Congress couldn't do under the Commerce Clause. And some people thought that was great and all right, because now we have finally achieved the Hamiltonian vision of a united republic under one unitary centralized government that can coordinate commerce and regulate one nation as one people. And there were other people who thought that wasn't such a good thing. So you went quite a while. I mean, the last time that that we had seen an act of Congress struck down as impermissible under the Commerce Clause was, I think it was, like 1936, right? Yeah, 1936 with the Carter-Cole case. And so from 1936 up until 1995, you had every single act of Congress passed with reference to the Commerce Clause upheld. You saw the court strike down no commercial legislation at all from Congress. This is very different than before 1937, where almost everything was struck down. But then in 1995, you had a very different makeup on the Supreme Court. You had Chief Justice Rehnquist, who was appointed by President Nixon, and you had a few judges who were appointed by President Reagan, and they had a different judicial orientation. They had a different judicial philosophy that was very different than that of the 30s through the 60s. They're different than what was the accepted standard way of thinking about the law in the New Deal and Civil Rights era. And so in 1995, we have a law that everyone expected would be upheld, yet the court struck it down. And so the court began to say, yeah, there are limits. There are limits on Congress's power under the Commerce Clause. And so United States versus Lopez, what's going on in this case? What are the facts?
A student carried a gun to school.
Mm-hmm. Why was that a problem? Other than, it's a...
It says you're not supposed to have a loaded gun in school.
Yeah, the Gun-Free School Zones Act, 1990. Could not knowingly possess a firearm in any place that was designated as a school zone or within 1,000 feet of a designated school zone. And so Alfonso Lopez is a senior in Edison High School in San Antonio. He brings his gun to school, and he's charged under this act.
There's no state laws against it?
There may not have been. I mean, for one, it's Texas, and also, there's he was an adult. He couldn't legally possess a handgun. I mean, there are people. So my parents are like in their 40s, and they grew up when they grew up in a time where people like brought shotguns on the bus to trade. So, of course, this was Grayson County, so people did that. But that was only in the 70s. That kind of stuff happened then, and there's still people. I mean, Representative Thomas Massey, who is representative. I'm not sure of which congressional district in Kentucky. He's actually proposed legislation to allow adult students, 18-year-old students, to carry firearms on high school campuses in the midst of the recent shootings. And so it doesn't surprise me that it's Texas and somebody brings a gun to school. I'm not saying that was so. Regardless, there was a law against it. There was a federal law against it, and this law just said cannot carry a gun you cannot possess a gun on school grounds or within 1,000 feet of the school grounds. Basically all it said. He gets convicted under this statute, and what does the court do? He argues it's not constitutional. How many people before him in over half a century had made probably a lot more viable arguments against the constitutionality of certain statutes that Congress passed and failed? And yet he makes this argument that no, this law cannot constitutionally apply to me. What does the court say? They agree. The Gun-Free School Zones Act is not constitutional. Why is it not constitutional? Why is this not a valid exercise of Congress's Commerce Clause power?
Not under the Commerce Clause. They don't have commerce over it.
Okay, so they begin with this. Chief Justice Rehnquist writes the opinion, and he begins by this is a very helpful opinion because it really gives a very categorical summary of what the how to understand the Commerce Clause. And so he outlines three categories here, three categories of Congress's power, three different ways, three different categories of things that Congress can regulate under the Commerce Clause. One is the channels of interstate commerce. So those are the navigable rivers, the interstate roads, the airways, the
Internet.
The internet. Yes, of course. Those are the channels. So those are pretty uncontroversial. Congress has pretty uncontroverted authority to regulate the channels of interstate commerce. The second is the instrumentalities of interstate commerce, the things, the persons and or things that are traveling from state to state. So things that are moving across state lines, people or things that are crossing state lines. That's definitely within Congress's power. The controversial category is this third one. Activities that substantially affect commerce. So all of so that was the Wickard versus Filburn. That was the National Labor Relations. All of these New Deal cases, they dealt with this third prong here, with activities that affect. That even though they're intrastate, even though there's not people or things crossing state lines, or even though they're not concerning a channel of interstate commerce, they're intrastate, localized activities that are affecting interstate commerce. And so this statute, now that it's being challenged, the federal government is defending the constitutionality of the statute, saying that it fits under this category. The court doesn't buy that, or at least the majority doesn't. So how do they say, no, it's not under this category? What's their reasoning?
It's not commercial activity or related to any economic enterprise.
It's carrying a gun is not an economic activity.
Carrying a gun is what?
Possessing a firearm, carrying a gun, according to the court here, is not an economic activity. Whereas Mr. Filburn, what he was doing was inherently economic. He was producing a commodity. Whether he was marketing that or not, he was producing a commodity. The nature of his activity was economic. The Darby Lumber Company, even though their operation of the business was an economic activity. All the cases we've read, you have activity that is economic in nature. The court here is saying, at least the majority is saying, here, this is not an economic activity. And because it's not an economic activity, we're going to apply a much stricter form of scrutiny to this, because we don't think that non-economic activity is something that Congress can consider as substantially affecting commerce. Now, if you're the government, what's your argument? If you're the Solicitor General before the Supreme Court and you're trying to convince the court, Your Honors, this does substantially affect the possession of firearms by students in our nation's schools, substantially affect interstate commerce. What is your argument?
You could use Justice Breyer's arguments,
The dissent, yeah.
and that is,
So what does he say?
well, education is important for interstate commerce.
Yeah, you don't have education. It's hard to get a job. You don't have a job. You're not buying and selling things, or as much. Maybe.
In the previous era, wouldn't they have just said that the gun was made somewhere else? That's commerce?
We're getting there. Even though this act was struck down, Congress reenacted it and just changed a couple words, and it's on the books and still valid law. This law was reenacted by Congress with one change, and we're going to get there. And Ms. Davies is on to the change. But if you're the government, your argument is, look, Congress found. They had testimony before panels. They brought people in. They did all of this legislative research, and they found that the presence of firearms on school campuses inhibits American students from getting a sufficient education to make them men and women who can participate in the economy and make our commercial atmosphere flourish. Guns on school campuses hurt commerce. It sounds very attenuated, but their argument was, yeah, it affects commerce. If you go to a school where there are no firearms, you're probably going to get a better education than going to a school where everybody's packing heat. And if you're getting a better education, if you're getting an insufficient education, then you're not likely going to be successful in your career and successful in your participation in the market. Now, but think about this. If that's your reasoning, don't other things other than firearms on campus, can you think of a lot of things that might inhibit education? That might make what's that?
Smoking.
Yeah, can Congress pass a law saying no smoking on any school campuses in the country? Could Congress create a federal school system?
It's doing that.
Well, I wouldn't say. There are some people who would say that, yeah. But I mean, could Congress say, look, in order to regulate commerce, we are going to make sure that all American students have a sufficient education. So we are creating the National School System Act. We're going to create in every county an alternative federal school to the state schools, and we're going to offer, or we're going to mandate that all the students there leave the state schools and come to the federal schools, because we have the power to do that under the Commerce Clause. Now that's pretty extreme. And I'd say somebody who's arguing on behalf of the government would say, that's not quite what we're arguing here, trying to support this, trying to defend the constitutionality of this Gun-Free School Zones Act. But what I'm saying is you can think of a lot of other things. And if you uphold this act, it virtually is affirming the notion of Congress having general police power, of Congress having plenary power like the states are supposed to. In the classical federalist notion of traditional notion of federalism. And so now that you have the new school of federalists on the Supreme Court, in the federal courts generally, you have people who are willing to say, no, Congress does have extensive powers, but Congress does not have general police powers. Those are left to the states. That's why anyone familiar with the Federalist Society? It's a conservative organization. Well, I won't say, I'd say you could call it conservative. It's a legal, it's an association of lawyers and judges that have this more conservative, classical federalist view of the Constitution and of constitutional interpretation. Yes.
Would you call that originalist or textualist?
Now, I would say you would call it. I would say in the Federalist Society, in those circles of jurists, you have people who are from both of those camps, both of those descriptions, and a few more. I would distinguish. So Justice Thomas here is the originalist. What is Justice Thomas? What's his concurring opinion? He agrees with the majority and says Congress does not have authority here. Congress, this is not a valid exercise of congressional authority under this category. That's what the majority says. Justice Thomas says, under the original intent of the framers, they never had envisioned this category to begin with. If you ask Justice Thomas, and you'll see this in each of his Commerce Clause opinions, he always writes either a concurrence or a dissent saying, this shouldn't be here. We need to go back to the pre-Wickard versus Filburn, back really to the Lochner era understanding of the Commerce Clause. That's Justice Thomas's originalism. He would say the original intent of the original meaning that the framers invested into these words did not fathom this kind of category of regulation. That's not what the majority is saying. The majority is saying this category exists. Wickard is still good law. We're not overruling Wickard or any of the other substantial effects cases. We're saying that the substantial effects category is not so expansive that it gives Congress police power. So the majority outlines a set of four factors that will help Congress, some guidelines that will help Congress understand when one of its acts are a proper exercise of commerce power under this third prong. And so what are those four factors that the majority talks about? Four factors. The Lopez factors. One, whether the activity is non-economic as opposed to an economic activity. So they're saying all of our previous cases before this case have all involved activity that was unquestionably economic. Here, the mere possession of a firearm is not in and of itself an economic activity. Therefore, we are highly suspect. If Congress is regulating intrastate activity that's not even economic in nature, it brings itself into strict scrutiny from the court. We are very highly suspect that this is most likely not constitutional. Second, whether the gun or whatever is being regulated had moved in interstate commerce. So here, there was no finding whether it had moved or not because the statute did not require that finding. The statute just said, you have a gun, you're guilty under the statute. Statute made no distinction of whether guns had moved in interstate commerce. The third factor is whether there had been a congressional findings of an economic link between guns and education. Now here there was some. There was some congressional findings. It's like, hey, we think that schools are not as good when there's guns. Kids aren't getting good education. And fourth, how attenuated the link was between the regulated activity and interstate commerce. So it was the second and the fourth factor here in this case that really killed this act constitutionally. That there was no requirement or finding that the gun at issue had been moved in interstate commerce, and the court thought that the possession of a firearm is so attenuatedly removed and remote from interstate commerce that it doesn't meet the substantial effects prong. You see what I'm saying?
I'm not quite sure, what kind of standards of evidence would there be, like, for these 4 points?
That's a good question.
Finding a link between guns and education, where do you get the evidence? How would you substantiate either side?
Well, and that one issue here is the extent to which the court is willing to defer to congressional findings. So the dissent, Justice Breyer in the dissent is willing to say, hey, if Congress thinks this is a problem, if they found that, we, the court, are in no position to question their findings. We are not in a fact-finding we cannot operate in a fact-finding capacity. We must refer to the fact-finding work of the legislature. And if they have made findings, then we can, if they can rationally base their conclusions, then that's the rational basis language.
So the court assumes by the time the case gets to them,
Yeah.
somebody has done that research on it.
Yes, but with this statute, that was not written into the text of the statute. There was no, as you call it, jurisdictional hook. There was no language that said, like the Civil Rights Act, like with the Civil Rights Act, the Congress had a preambulatory language, prefatory sections that said discrimination affects interstate commerce. That wasn't in this act. You didn't see that. And so you didn't see any language that said carrying guns on school affects interstate commerce, or we're only going to prosecute cases where the activity affects interstate commerce. But the court ultimately said, this activity we don't think is commercial, because we don't think that it affects commerce because it's not economic in nature. Now, like I said, Congress, what Janet Reno, the Attorney General, advised Congress to do is, hey, court says this language was missing and that it didn't affect interstate commerce. Let's do a mulligan. Let's go round two. Let's reenact the statute, and we'll add a little phrase in there that says, if anyone is carrying a firearm that has passed in interstate commerce. Now, I've owned a lot of guns in my time. I don't think I've ever owned one, or I don't think anybody else has ever owned one that has not crossed state lines. What do you guys think? Or at least some component of the firearm has not crossed state lines. So now, the act was just modified with some language, but in reality, is the scope of the act really different? Or is it just a formality? And so since 1996, this law has been back on the books in its modified form. It has been challenged in the courts, but to date, none of those challenges has been successful. And so now, what's required? Congress can now, under the Lopez standard, can pass statutes like this that seem to be criminal laws, criminal statutes, as long as they add some kind of reference or jurisdictional hook that says affects interstate commerce or is involved in interstate commerce. So if you ever read any federal criminal statutes or federal regulations, they will always, post-Lopez, have some kind of reference to interstate commerce, if they're passed with reference to the Commerce Clause. For instance, there's a federal murder statute that applies only if you, like, let's say somebody gets murdered in Mammoth Cave National Park. You're in exclusive federal jurisdiction. You get murdered there. You murder somebody there. You're in federal court rather than state court. But if you commit a crime that is, Congress does not have the power to make a generally applicable murder statute. Only the states can do that, unless you found a way to murder someone that affected interstate commerce. And so Congress could write laws, ostensibly, and they'll be upheld ostensibly if they have that jurisdictional hook. But that's assuming that it is regulating activity that's economic in nature. And we don't really have a lot of clarity on what is economic and what's not economic. How would you go about distinguishing activity that's economic from non-economic? That's past me. Anybody have a workable standard there?
I have a question.
Yes, sir.
So it seems pretty clear that Congress isn't interested so much in regulating commerce as in outlawing guns, but don't they come up against the Second Amendment, right?
Well, yes, if there's certain, of course, this was before up until this point in 1995, I would say most of a lot of judges and a lot of lawyers believed, even in 1995, that the Second Amendment did not protect an individual right to bear arms. Now, we know there's been a couple cases. There was a Chicago case and there was a District of Columbia case, both of which went to the Supreme Court, that have recognized that states and federal government have to respect it as an individual right, and there are certain limits to what Congress can and can't do. The Second Amendment was really not discussed here in this case. It was. I don't even know if the plaintiff, Mr. Lopez, if he even made a Second Amendment argument, he would have definitely lost, even if this case had been today, he'd have lost under a Second Amendment argument.
Just seems like Congress could extend beyond question schools to cities, to anything, and therefore just outlaw guns under the Commerce Clause.
Yeah, but the same way that I would say Congress can, under the Commerce Clause, as the Commerce Clause in a vacuum, could outlaw the interstate sale of Bibles. But the Commerce Clause isn't in a vacuum. There's other provisions of the Constitution that apply, for instance, the First Amendment. And so that runs into that. And so let's say that Congress had found, hey, we think that there are neighborhoods where there are lots of firearms, that is correlated with high poverty rates and high crime rates. And so we think we're going to designate certain neighborhoods that are going to be gun-free zones. Well, at that point, you begin really putting a substantial burden on someone's Second Amendment rights. So at that point, you're having a convergence of a congressional prerogative and an individual right. And so ostensibly, the individual right's going to win out there. But if Mr. Lopez had made a Second Amendment argument here, he'd have lost, certainly. Any other questions before we move on to Morrison? Morrison. What's going on in this case? United States versus Morrison. Violence Against Women Act. Now, did this act criminalize violence against women?
No.
No.
No criminal charges are placed.
It didn't criminal. No, this is not a criminal statute. What instead is this? What is this? What does this create?
It means to go to court to recover damages.
It creates a statutory right of action. So just like the Civil Rights Act, the Civil Rights Act is not if somebody violates the Civil Rights Act, they're not going to go to jail. They're going to have the federal statute creates a cause of action, a means by which somebody who has been a victim of discrimination or under this law of violence against women can have a right of action to bring a lawsuit in federal court. Now, the two fellas involved in this case were accused of rape and assault, and they went through. They weren't indicted. So those are obviously both state law crimes in every state, but they weren't indicted. And so Ms. Brazoncala then finds herself with no other recourse but this implied right of action. So the statute gives women who were the victim of certain forms of gender-motivated violence a right to bring a lawsuit against the aggressor in federal court. That would not, the simple loss, that you would have to bring that as an assault or a battery lawsuit in state court, not in federal court, with state judges who Congress thought may have been more paternalistic or patriarchal and less friendly to women. And so they wanted to create, hey, in the federal courts where we have these, a system that's somewhat more progressive, we want women who are victims of gender-motivated violence to have recourse there. So that's what this statute did. And it was passed with reference, and this is not the first time. If we make good time, we will talk about this case again. Because there were two arguments here. This law was passed with reference to two constitutional powers. One is the Commerce Clause. The other is Section 5 of the 14th Amendment. And I'm hoping that our very last class we will get to discuss that. I'm trying to make it there. And so hopefully, Lord willing, we will discuss this case again, not the Commerce Clause aspect, but the Section 5 enforcement power aspect of the case. But it was unconstitutional, spoiler alert, it was unconstitutional with reference to both powers, to both enumerated powers. This act was not constitutional, according to the court. And so why wasn't it? Why was the Violence Against Women Act, which gave women who were subject to gender-motivated violence a civil right of action in the federal courts, why is that not constitutional? Why is it not commerce power?
Justice Thomas concurring is interesting.
The same thing. It's the same concurrence he had in Lopez. It's essentially it's the original. It's his normal originalist line. This is not what he's kind of like. I don't care what y'all say. I'm going way back before Wickard v. Filburn because y'all have had it wrong for a long time. It's basically Justice Thomas'
Police
position.
powers belong to the state, basically.
So how is this how are police power? How do they come into this? How is this? In what way is this law a police power? But let's back up a little bit and let's go to the first level of this onion and talk about commerce. Which of these, Congress has passed this with reference to, at least in one sense, the Commerce Clause. Which of these three categories is Congress making reference to? 1, 2, or 3?
Substantial effects.
The third category. The third of the Lopez categories. Okay? So the substantial effects. And so they're saying, the argument makes sense. The government's argument is, and look, they did their homework. They learned a bad lesson. They learned a hard lesson from Lopez, and so they had extensive congressional findings that gender-motivated violence discourages women from participating in the workforce, discourages women from being economically self-reliant, discourages women from pursuing education and career goals. And so they're saying, look, violence against women We are going to shore ourselves up because we do not want another runaround like what we have with Lopez. It really affects, here are all of these findings after all this testimony we heard from people to come testify before congressional committees of women whose commercial capacity was diminished because of gender-motivated violence. So yes, this substantially affects commerce.
Yes.
Why is it still not constitutional?
Because the court didn't agree.
Well, did the court express, did they say,
It was an attenuated effect, not a substantial effect.
well, put it this way though. Does gender-motivated violence discourage commerce or affect commerce any differently than non-gender motivated violence? If I threaten, okay, if I really want to discourage someone from engaging in commerce, if I really want to inhibit their commercial capacity, I'll murder them. Does Congress...
The job of breaking their legs like the for crime
Yeah.
people do, that would also inhibit them. But I would say that if that was, the victim was a male rather than a female, probably his attackers would have been prosecuted. And the question is, why wasn't this attack prosecuted?
Well, but beside the issue of whether I was prosecuted, I mean, the issue here is, yeah, what violence doesn't affect interstate commerce? Yeah, Congress, you good job. You found out that gender-motivated violence affects interstate commerce. Good for you.
So does everything else.
So does everything. So does every kind of violence.
Intercourse among people goes back to that.
Sure. But at this point, if you find that gender-motivated violence affects commerce, then there's nothing to preclude a finding that any other kind of violence or really any other kind of activity affects commerce, even if it does. But at that point, Congress is in a de facto capacity as a general police sovereign. And so this is where you see the purest articulation of the new federalism, of the new understanding of Congress. You do not have general police power. Yes, we hate it that all these women are being victim to violence, but that's for the states to deal with. Because
if they don't deal with it, I mean, there's other places that has happened. Like
that's for sure.
The swimmer that raped a lady that was passed out.
Yeah.
And they dealt with it very leniently.
And
People
so
thinking that was not very
I'm not defending the decision. I'm simply telling you what the decision is, and there's all kinds of arguments against it. But how would you respond?
Can the state say, or the Congress says, well, state, if you don't do your job, we'll have to have a backup?
No, they can't. Congress can't do that because Congress cannot commandeer the state governments to fulfill Congress's regulatory regime. Congress cannot say, states, you must do this. Now, as we're going to talk about next week, the Congress can give money to the states with certain conditions. They can hold a carrot up for the states to act the way Congress wants them to. And they can threaten to take that carrot away if the states don't. But Congress cannot compel states to legislate or commandeer the state governments, the state legislatures, the state law enforcement, commandeer them to enforce or enact federal law.
But why does it have to have anything to do with commerce? I mean, why couldn't the whole case be, the whole act, Violence Against Women Act, be argued in some other way? Forget about it.
It was. The other, and hopefully our very last class will be able to talk about the section 14th, section 5 of the 14th Amendment was the other reference power. Just to give you the long and short of it, Section 5 of the 14th Amendment only gives Congress power to regulate the activity of state actors, of government actors, not individuals, not private individuals. And so Congress does not have the power under Section 5 of the 14th Amendment to pass legislation which regulates the conduct of private individuals, only state actors, only government actors. So that's the answer to that question. So without the Commerce Clause, if we understand the Constitution as a floor, as a necessary foundation of any legislation that Congress enacts, if there's no foundation with the Commerce Clause, and there's no foundation with Section 5 of the 14th Amendment, what's the foundation? It's one of those things, there ought to be a law. Violence against women is bad. Somebody ought to do something. But can we just make up an exigent power that Congress has? Yes?
The federal government can put pressure on the state, though, not to receive certain funds, like you were saying. So then they could essentially force them to put in new laws. It would be after the fact.
And we're going to talk about this next week. But there's limits to that. The conditions on the funds have to be germane to what the funds were given for. So the states are not receiving funds for their creation of implied civil rights of action or statutory rights of action. There's no states that are receiving funds for that. So Congress cannot say to the states, we're going to take away your Medicaid money or your Medicare money unless you create this statute. They can't do that. That's unduly coercive and violates the 10th Amendment, as we'll talk about next week.
Or protecting is that right?
Oh, I don't know. Well, so I guess what I'm saying is the reason this was struck down is because the reasoning of the majority was we know violence against women is bad, and it might even affect interstate commerce. But if we allow that to be a legitimate basis of congressional power, then because all violence affects commerce, violence is a non-economic activity. Just violence per se is non-economic activity by nature. And so at what point, if we upheld this, it would virtually be saying Congress can act in the capacity as a general police sovereign, as if it's a state, like one of the state governments. Real quick, just a quick mention of Gonzales v. Raich. How is this case, this is the Pot case, how is this case any different than Wickard v. Filburn? How is it any different at all? Instead of, I'm just little old Roscoe Filburn raising wheat, it's, I'm just sick little Angel Raich growing 6 marijuana plants. It's a Controlled Substances Act here. We'll mention this case really quickly in our next class, and we'll go over just a review of how we should understand the modern Commerce Clause analysis. And then we will talk about taxing and spending. Fun. Speaking of taxing and spending, there's a handout here on the front. I don't know if you've got a copy of it yet. It's next week's reading. There's just a few cases on our taxing and spending unit. If you have any questions, please come up and see me.